Subscribe to our YouTube channel and press the bell icon to get the latest updates.
In a recent ruling, the Delhi High Court on 7th May said that it is a constitutional right of an individual who is under detention to consult with a lawyer and that this right cannot be diluted by the state, that is the government authorities. This ruling was passed in a petition filed by the Delhi riots UAPA, that is Unlawful Activities Prevention Act, accused Shifa Ur Rehman, who is the president of the Jamia Millia Islamia Alumni Association. Now, the constitutional right that the Delhi High Court here was referring to is one under Article 22 of the Constitution, and that's what I'll be talking about in today's episode of Know Your Constitution or KYC. Now we know that Part 3 of the Constitution lists down certain fundamental rights, and within these we have Article 22, which provides for certain protections against arrest and detention and protections for those who get arrested or get detained. Now, subclause 1 of this provision, that is Article 22, guarantees several rights. So it says that whoever is arrested should be informed of the reason for their arrest as soon as possible. And secondly, Article 22(1), Article 22 subclause 1 says that a person who is arrested shall not be denied the right to consult and to be defended by a legal practitioner of their choice. And it is the second right that we'll be focusing on in this video. Now, the Supreme Court has interpreted this right in several cases, but here I'd like to refer to one particular case which is titled Francis Corelli Mullin versus Administrator, Union Territory of Delhi and others. Now, this judgment was passed in 1981 and still holds ground. In this case, a British national, that is the petitioner Francis Mullin, was arrested under the Conservation of Foreign Exchange and Prevention of Smuggling Activities Act. And she had now basically raised questions on her right under the law to have interviews with a lawyer and her family members. Now, she was detained in Tihar Central Jail but had told the Supreme Court that to arrange an interview with her lawyer, the lawyer had to first get prior appointment from the District Magistrate Delhi, and that the interview could only take place in the presence of a customs officer nominated by the Collector of Customs. This was as per the conditions of detention that had been laid down under the law by the Delhi administration, and she had now challenged some of these conditions among a few other conditions. Now, the Supreme Court essentially quashed these conditions that were placed on her having a consultation with her lawyer while relying on Article 22, subclause 1 of the Constitution. The court highlighted the fact that such conditions cause, and I quote, great hardship and inconvenience. And the court said that from a practical point of view, the right to consult a legal advisor with such conditions would just remain an illusion. The point here being that the court breathed life into the provision, saying that while prison regulations can regulate this right of an arrested or a detained person to have an interview with a legal advisor, it cannot lay down arbitrary or unreasonable procedure for regulating such an interview. Basically said that this would otherwise violate Articles 14 and 21 as well. Even these conditions therefore need to be reasonable. Now, Section 41D of the Code of Criminal Procedure, which was introduced through an amendment which came into effect in 2009, basically says, and I quote, when any person is arrested and interrogated by the police, he shall be entitled to meet an advocate of his choice during interrogation, though not throughout interrogation. But experts therefore always often point out that the boundaries of this right are a little hazy, because who decides when a person can meet their lawyer and for how long during that period of interrogation. Now, let me bring you back for a bit to Shifa Ur Rehman's case and tell you a little bit about what happened there. Rahman was basically arrested on 26 April 2020, and since then applications for extending his detention and for the period of investigation under UAPA were filed by the prosecution. Now, in June, he filed an application to consult his lawyer or counsel through video conferencing or telephonic conversation. This was also, be mindful of the fact that this was also during the time when the country had a lockdown imposed due to COVID-19. Now, while these applications were allowed by courts, low courts, the request was either kept pending or kept getting shuttled between different jail authorities. And in the meantime, his period of detention and investigation was extended more than once. The case reached the Delhi High Court, which now referred to Article 22 and ruled that Rahman was in fact denied his constitutional right to consult with his advocate. The court also said that in such cases, the authorities cannot shirk away responsibility by saying that not giving an opportunity to consult with a lawyer actually did not prejudice the accused in any manner. The court basically asserted that this is a constitutional right, and so the government cannot dilute the right on the ground that no purpose would have been served even if such consultation was permitted. Now, while this case was being heard, the High Court at least ensured that Rahman had full access to his lawyer and was given complete opportunity to consult and instruct him, but he wasn't granted his final relief by the High Court that he had sought for quashing of the order that extended his detention and period of investigation, because while this case was pending, the High Court noted that the extended period was already over and charge sheet had already been filed in the case. Now, Article 22 was also widely discussed in the case of 22-year-old Disha Ravi, who was arrested in February this year in connection with what we now call the toolkit case. It was alleged that she was produced before a magistrate without her own legal counsel and that she had to make submissions in the court on her own, thereby leading to violation of this right. In fact, senior advocate Rebecca John had then criticized her remand, Disha Ravi's remand to police custody, citing Article 22 of the Constitution. So John had essentially said that the magistrate remanded Disha Ravi to police custody without first ensuring that she was being represented by a lawyer, among other things. Now, while the Delhi police had defended itself, saying that since Disha Ravi's lawyer couldn't reach the court in time, she was given a legal aid lawyer in the meantime, Disha Ravi was finally granted bail a few days later on different grounds. Now, this right also came into the limelight after the COVID-19 lockdown was imposed starting March 2020, and after that, physical vakil kaidi mulaqat, that is advocate prisoner mulaqats or meetings, were stopped in all jails across the country without putting an alternative arrangement in place. But experts have then highlighted that this violates the rights of those prisoners under Article 22, after which a few arrangements were finally put in place. So, for example, when this was brought to the attention of the Bombay High Court, it directed the prison department to install smartphones in jails and arrange for lawyer-prisoner meetings through video calling in all the jails. As per reports, the prison officials then bought over 70 smartphones for use across 45 jails in the state to allow video conferencing and replace physical mulaqats, so that this basic right of the prisoners under or of those arrested or detained under Article 22 is not hampered due to the COVID-19 lockdown. This is Apoorva Mandhani for ThePrint. For more such videos, subscribe to our YouTube channel and follow us on Twitter, Instagram and Facebook.